I respectfully ask the court to consider a sentence that allows me to continue caring for my children, continue my education, and continue being a productive member of the community.
Violating the court order was clearly intentional. I've read the text of this. There was no misunderstanding about whether you were or were not allowed to have this conversation. For whatever reason, you decided that you were above the order, not once, but twice. Sir, raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communication? Today is the date we set for a bond violation hearing. Ms. Cox, it is alleged that you violated the conditions of your bond. If that's true, you could be guilty of contempt of court. Contempt of court is punishable by 93 days in jail and or $7,500 in fines, consecutive to that which you already face. You have the right to have an attorney. Mr. Oaks is representing you. You have the right to have a trial, not by a jury, but just by a judge. At that trial, it'd have to be proven that you violated a court order beyond a reasonable doubt. Mr. Oaks, how are we going to proceed today?
At this time, Your Honor, she will plead guilty to violating the court's order.
Ms. Cox, if you proceed with pleading guilty, you'll be giving up your right to have a trial on whether you violated the court order. Is that what you wish to do? Yes. Raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth under penalty of perjury? I do. Okay. Ms. Cox, is it true that you were arraigned on April 5th, 2026 and told to have no contact with Mr. Grant? Is it true that after you were ordered to have no contact with Mr. Grant, you called him from the county jail?
Yes.
Looks like at least 2 times he answered and you actually spoke to him.
I did.
Did anyone make any promises or threats to you to get you to plead guilty here today? Are you pleading guilty of your own free choice? You find your guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record upon which base your plea is therefore accepted. Do the people wish to be heard on sentence?
No, Your Honor, the people defer to the court on sentence.
Mr. Oaks, on
And
sentence.
at this time, Your Honor, would the court look to move to sentencing now on this or on June 16th when she has her underlying sentencing on her
No, we'll sentence for a bond violation, contempt of court today, and then we'll address their balance on the regular sentencing day.
Okay. Well, Your Honor, at this time, we've presented documentation to the courts. My client understands the seriousness of a no contact order and court orders altogether. At that time, all of this was new to her. True, she had been arraigned by the magistrate, told not to have contact with Mr. Grant, and she then proceeded to go to the jail and call, and as noted in the calls, she first was saying Devin, when they're asked to say name, because that's the name of her oldest child, and she was hoping that that would trigger that individual being on the other end of the phone, that he would give the phone to Devin so she could talk to her children, because again, since having been arrested, she had not spoken to her children, and her children were in Mr. Grant's care, not their father's care. So she was asking for him, and when he said, okay, they're not here right now, she emotionally went on with a conversation with him, the protected party. And it was clear that, again, I'm not supposed to be talking to you. And at some point he said, hey, we're not supposed to be talking, but they still talked for some minutes. She gave him instructions as to how to locate the kid's father so he could come and get the kids, her not knowing how long she was going to be incarcerated. And it was actually the kid's father who did eventually come and bail her out of jail. So, and as the second letter that I gave you was from the kid's father, who made it clear that she's the primary caregiver. He has no space for the children where he lives. So any term of incarceration that this court would look to impose would more so cause harm to the children, innocent children here in this situation, because they wouldn't be able to be in their home because she'll be in jail. And the father said he's renting a room from someone, so they can't be there with him. So we asked this court to take that into consideration, in addition to the fact that we have a Ph.D. candidate here who's here on a work visa. She's here in the U.S. to go to school. She never has been arrested before in her life. She has no criminal record whatsoever. That was the other document that we gave to this court. She took the steps to contact her home country and get a criminal history report. I do understand that it's not in English, but I use my phone to take a picture and interpret it and translate. And from that, it shows that she has no criminal record. So, and it goes behind, in addition to what she says, that she has never been in trouble before. And we do know most of the time when individuals violate the court orders is because of anger. They're trying to manage a situation. They're trying to control someone. They're trying to not let go of a relationship, whereas they are taking actions that are directly against the court proceedings. That's not what we have here. We have this mother who's been arrested for the first time ever in her life, confused by what is being said. She's being told that she's being charged for trying to hit Jay with a vehicle, and she's confused by that, which he was confused as such, as my understanding. That's why those charges got dropped, because that never happened. But was lost here in a situation before this, in this court proceedings, not knowing what's happening, having a full understanding of everything. So we like the court just to take this into consideration, that her phone calls was not with a malicious intent. We do know the seriousness of following court orders and how order is basically maintained by following the rules. So, and she now better understands that. She understands the significance of this. She understands the consequence of possibly being placed in jail behind making this phone call, because she understands now how serious this situation is as far as in following the court's orders. She has done so accordingly ever since, and not having contact with him as such, because they did live together. When she first was released from jail, she had to live in a hotel room for 2 weeks with her child until Jay moved out of their home. Now she's back in the home and he's living elsewhere, because again, they are taking this court order serious. So I'm just telling the court all of this to say that she meant no disrespect to the court by making the phone calls. This is her first time going through this situation, and she made a foolish decision to stay on the phone call. Even when she made the call to check on her kids, when that child didn't answer, pick up that line, she should have hung up. Once he said they're not here, she should have hung up. Would have still placed her here before the court, but it would have looked in a better light than for her to continue to have this conversation with him. So we just want to just reiterate that her actions was not in defiance. It was her being emotional and concerned for her children. And we asked this court to consider a non-jail resolution here for this matter. As stated, she's going to be under this court's authority once she gets sentenced, and her underlying matter, she can be ordered to attend counseling and anything else that this court feels is appropriate. But we ask this court to take into consideration that, again, she's here on the work visa. She's a Ph.D. candidate. We've submitted a letter from her advisor speaking to her as a person, the actions that led to her disobeying the officer and so forth. That's not her. So her not following the order that the magistrate gave her not to call Jay. As I said, that wasn't in defiance. That was one of the numbers that she just knew. So many individuals don't have numbers memorized. So she's in this country not knowing many people. So she reached out. She should not have. She acknowledged she should not have, but she asked this court to take that into consideration and making this decision as far as a punishment for her actions. Thank you.
Your Honor, I would just note for the record that I do have the audio of the calls if the court at some point is interested in hearing them. That's all.
Does it add anything above and beyond the text of the report?
I think the text of the report is pretty consistent with the content of the calls. I just wanted to let the court know that if you would like to hear the calls, I have.
Mr. Oaks, do you want your client to make a statement on her own behalf before I impose sentence?
Yes, she said she had a statement to make.
Your Honor, I want to begin by saying that I understand why I'm here today and I accept responsibility for violating court's no contact order. I knew I was not supposed to have contact and I should have handled the situation differently. I truly regret my decision. I was scared and worried about my children. I called the only number I knew I could use to try to check on my boys and make sure they were safe. What started as concern for my children turned into a conversation that should not have continued. I understand now that even if my intentions were not malicious, I still violated the court's order and I take responsibility for that. Your Honor, I respectfully ask the court to please consider who I am as a person outside of this mistake. I have never had a criminal record before this. I'm a Ph.D. candidate at Michigan State University. I work as a teaching assistant and I have dedicated my life to education, my students, and especially my children. Most importantly, I'm a primary caregiver for my two sons who are 11 and 8 years old. They depend on me every single day. Their father currently rents a single bedroom inside another person's apartment and does not have appropriate space for their boys to live with him full time. If I'm taken away from them, there is no stable plan in place for their care, and they will suffer emotionally, financially, and academically because of my absence. I'm not asking the court to excuse what I did. I know I made a mistake, and I know I should have exercised better judgment. I'm simply asking the court for mercy and the opportunity to learn from this without my children losing the parent they rely on every day. This situation has already had a major impact on my life. I have reflected deeply on my actions, and I can promise the court that it will never place myself in this position again. I respectfully ask the court to consider a sentence that allows me to continue caring for my children, continue my education, and continue being a productive member of the community while still holding me accountable. Thank you, Your Honor.
Violating the court order was clearly intentional. I've read the text of this. There was no misunderstanding about whether you were or were not allowed to have this conversation. For whatever reason, you decided that you were above the order, not once, but twice. And for the fairness and consistency, everyone who comes before the court who has violated the court orders, a jail sentence is appropriate for your blatant disregard of the court order. However, I am taking into consideration your lack of criminal history and the fact that you need to make arrangements for your children. The sentence of the court is 3 days jail beginning tomorrow night, May 13 at 8 p.m. That will allow you to make arrangements for their care term, which will probably go in Wednesday night and be out by Friday morning. Since I gave you a sentence of jail, you do have the right to appeal my sentence. If you'd like to appeal and you need a public defender to assist you, you need to make your application within 14 days. Counsel?
Thank you, Your Honor.
Nothing from the people.
All right, thank you.